news, hijab is not an essential religious practice. The Karnataka High Court has ruled a short while ago in a huge setback to students who had challenged a ban on wearing the hijab in class. 5 petitions from Karnataka had challenged the ban in court. Ahead of the order, the state government banned large gatherings for a week in state capital Bengaluru to maintain public peace and order. Mangalore has also banned large gatherings from 15th to 19th of March, and schools and colleges are closed in Udupi. Today, the petitioners are from Udupi, and it all started from a college there. The petitioners, including a dozen Muslim students, told the court that wearing the hijab was a fundamental right guaranteed under India's constitution and an essential practice of Islam. After 11 days of the hearing, the High Court reserved its judgment on February 25th, and its verdict today says that it is not an essential practice, and has also said that it is reasonable for colleges to implement uniform, that a uniform is a reasonable restriction on fundamental rights. Remember, this had blown up into a massive controversy starting from Udupi and protests in various parts of the state as well, in other districts, and after the first college, other colleges too banned the wearing of hijabs in schools, in their junior colleges. However, and this is something that the students said they were allowed to do earlier, and many students have in fact missed out on classes and even taking exams during this period, as there was the High Court's instruction in place that till they gave the final verdict, no religious clothing was to be allowed in any of the schools or educational institutes. And therefore you saw these visuals of students being forced to remove their burqas and hijabs. Even teachers were being forced to remove their burqas before entering, or hijabs before they were entering the school, the educational institution campuses. And it had been
wearing of hijab forms part of Islamic faith. That is, whether it was an essential religious practice. Court has held, accepting the contention of the state, that it is not part of ERP. Secondly, it has held that whether insisting on institutional discipline, that is asking them to wear the uniform, amounts to violating the right guaranteed under Article 19, which is freedom of speech and expression. That also has been negatived, holding institutional discipline prevails over individual choice. Thirdly, about the government order, the stand of the state, wherein its state had said that it would not interfere in these matters and it would leave it to the concerned institution, that was sought to be criticized by saying that it resulted in non-application of mind, it resulted in discrimination, etc. That has also been negatived. And in all the the High Court has rejected all the petitions. According to me, this judgment marks a paradigm shift in interpretation of Article 25 of the Constitution. It restates the position of law as held by the Supreme Court in Shabarimala by saying that what is essentially religious is not sufficient. What is required to be shown is essential to religion. And therefore, whatever be the individual choices, ultimately institutional discipline prevails over individual choice.
So when it comes to the essential practice, the court, it doesn't come under that
ERP.
ERP. So how it's been considered? Because the councils have been argued the same matter, making to understand the bench that this is the essential practice.
See, how you determine what practice is an essential religious practice is laid down by the Supreme Court by laying down 5 tests. Test number 1 was whether the practice preceded the religion itself. Number 2, without practicing the same, whether religion will cease to exist. Number 3, whether it is obligatory or optional. And 2 other tests have been laid by the Supreme Court. By applying those tests, it was clear that this does not form part of essential religious practice.
So the petitioners clearly said that even before the judgment that they will go back to the Supreme Court and they'll fight it again.
See, under our scheme of the Constitution, any order passed by the High Court, you can avail the remedy of filing a special leave petition and appeal before the Supreme Court. It is perfectly open for any of the parties to move the Supreme Court.
But you're satisfied?
But I am very sure that the judgment which has been delivered by the High Court is based on sound legal principles and based on factual foundation.
Sir, it's been 11 days continuous hearing was done. Before that, do you think the bench has been considered each and every point of it?
Most certainly. You could see the judgment itself. It is a very well considered judgment running more than 200 pages. So obviously the court has taken it considered all the submissions made by the respective counsel.